Hello, and welcome to the Eversheds Sutherland Webcast, Global Share Plans, Hot Topics and Current Developments. If you have questions during the webcast, please submit them via the Ask a Question text box on your viewing console. CLE credit is approved for this webcast in California, Georgia, New York, Nebraska, and Texas, and is pending in Illinois and Virginia. If you would like to receive CLE credit for this webcast, please download and submit the CLE sign-in sheet and evaluation forms. We will provide you with a confirmation code for you to enter on your sign-in sheet. This webcast is being recorded, and the final version will be posted to the Eversheds Sutherland website within the next week. I will now turn it over to Brenna Clark, partner at Eversheds Sutherland.
Hello and welcome. My name is Brenna Clark, and I am in our U.S. Employee Benefits and Executive Compensation Group. Today, my colleagues and I will be talking to you about three key issues that might impact your global share plans. First, you're going to be hearing from Mathew Gorringe, who is the head of share incentives in the UK. He's going to speak to you about recent changes to securities laws across Europe and how those changes might impact your global share plans. Next, we're going to hear from James Ruane, a principal associate in the UK's commercial team. He's going to be discussing GDPR and some considerations there that you might need for your global share plans. And finally, we're going to hear about clawbacks, and we're going to hear from a number of jurisdictions. I will be speaking about some of the considerations in the U.S. We'll turn it back to Mathew to speak about a little bit about the UK's considerations. And additionally, we will hear from Marcello Floris, who is in Italy and deals with labor law and trade union issues. We'll also hear from Vincent Roulet, who is in France, and also deals with labor law and trade union issues as well as pensions. And we will also hear from Luis Aguilar, a legal director in Spain who deals with benefits, employment, and also labor law. And so with that, I'm going to turn it over to Mathew.
Hi, folks. I'd like to have a chat with you about some recent changes to securities law. You may well be aware that across the EU there is the securities laws are governed by the EU Prospectus Directive, and that governs the laws that apply to offers of securities across countries in the European Economic Area. However, the EU Prospectus Directive is going to be replaced by the Prospectus Regulation, which will take effect with full application on July 21st, 2019. However, before the introduction with full effect on the 21st July 2019, there are a number of provisions which are being introduced with effect before that date. And there is one particular change that may have an important impact on the operation of global employee stock purchase plans. You're probably familiar with this, but under the current EU Prospectus Directive, offers of securities with a total consideration for the securities being offered across all of the EEA states, which is less than 5 million euros, is exempt from the obligation to publish a prospectus. The way that works is there is a 12-month look-back period to take into account any offers of securities that have been made in the 12 months preceding the offer with which you're concerned with, to see if you tip over the 5 million euro limit. Unfortunately, the new prospectus regulation has significantly reduced that threshold from 5 million euros to 1 million euros unless the particular EEA state concerned opts to increase its own national limit. So basically, unless a country does opt to increase its national limit, the limit will be now 1 million euros calculated over a 12-month period. and if you break that limit, then you will fall into the obligation to produce a prospectus, which is a very costly affair. Just to give some example around that to make sure you see what I mean, I've given two examples on that page. The first one deals with the position before the 21st July 2018, and you can see that from that example, if a company wanted to make an offer of securities across the EEA of 4.5 million euros, and in the 12-month period prior to that date of that offer, it had made an offer or offers of securities across the EEA of less than half a million, then that 4.5 million offer would be exempt from the obligation to produce a prospectus. Once the changes are introduced after July 21st, the position completely changes. So there's an example there where a company wants to offer securities across the EEA of 999,000 euros. Now, if it hasn't made any offer in the 12-month look-back period, that particular offer would be fine. There wouldn't be a need to produce a prospectus. But if it had made an offer in that 12-month look-back period of €1 or more, then unfortunately that would trigger the requirement to actually make a prospectus. So just a couple of points. When you're looking at this, you have to look at the offers made in all EE states. You can't just look at one particular offer, so you need to consider where all the offers are made. And one of the things that usually crops up is there are exemptions, other exemptions from the need to produce a prospectus, and one that's heavily relied on is the fact that less than 150 people are offered securities in a particular EEA country. Where we found in the past that exemption can't be relied upon is with global employee stock purchase plans, where there may be a significant number of employees in particular EEA states that are being offered securities on a monthly basis. So that's really the area that needs to be probably considered most in respect to this change. As I said before, there is an obligation for each country to opt out of that 1 million threshold, and they can increase their national limit to 8 million euros. The UK has actually adopted that, so there is now an 8 million euro limit in the UK. I wonder if you could comment on what the position is in France, Vincent.
Yeah, okay. So far, France has not set any rule derogating from the regulation. So since July 21, the threshold of 1 million provided for by the European regulation has applied. However, the financial market... Okay, yeah, but it will change. The Financial Market Control Authority has made a recommendation to increase the threshold up to 8 million. And the government agrees, and a bill is currently being discussed. It shall set the threshold at 8 million, and it will come into force around next February.
That's interesting. Marcello, how about from Italy's perspective?
Yes, we have still a discussion going on because the Stock Exchange Authority is still considering these options. And so we have three different possibilities. One is to maintain the threshold at 5 million. According to the provision, the existing provision in the banking laws, considering the fact that this threshold of 5 million euro is not considered to be a public offer of securities, or to raise the threshold to 8 million. Or again, a third possibility would be to raise the threshold to 8 million, but only with reference to specific cases, meaning For instance, securities offered at the same time or following the listing or in a SMA growth market, and leaving for all the other cases the threshold of 5 million euros.
That's interesting, and I think what comes across there, hopefully for the audience, is just how complicated this now is, because each jurisdiction is doing slightly different things. And although obviously the prospectus rules were introduced to sort of create harmonisation, in actual fact, there's a bit of a patchwork going on across Europe, making it even more important to look at this issue where you think it might arise. Just in terms of timing, I think I'll hand over now to you, James.
Thanks, Matt. By way of introduction, my name's James Ruane, and I'm a member of the Eversheds Sutherland privacy team. I've worked closely with Matt on a number of matters that address GDPR compliance gaps on global share plans. And from that, we've developed an understanding of what some of the key pitfalls are. And really, we just wanted to use this session to share some of those experiences with you. So hopefully, you can take those lessons and apply them when you come to introduce your own share plans. So I'd just like to start with a quote from Jan-Philippe Albrecht, who's the rapporteur who was responsible for making sure that the GDPR came into force. And he said that the result is something that makes, as we intended from the beginning, everyone equally unhappy, which isn't quite the ringing endorsement that you might want given his role, but it is a position that I can sympathise with given the massive burden that's been placed on organisations from the introduction of the GDPR. He does go on to say, though, that at the same time, it's a huge step forward for all sides involved. If you think back, the previous data protection regime was born out of a 1995 directive, which was before even Google had been founded. So something did need to change. The law did need to be updated, if nothing else, then just to reflect the huge advances that we've had in technology. And as a result of that, we've been given the GDPR. Moving on, I'd just like to spend a couple of minutes running through some of the key impacts of the GDPR generally. Most of you will be aware that the GDPR came into force on the 25th of May 2018. It places increased compliance obligations on controllers, introducing a number of new obligations, but also making existing obligations stricter. Through this section of the presentation, I'm going to be referring to data controllers and data processors. By data controllers, what I mean is an organisation which, alone or jointly with others, determines the purposes and means for the processing of personal data. So to put that in real terms, really, we're talking about an employer will typically be the controller of its employees' personal data, because ultimately it can decide what it does with the data that it's collected. When talking about data processors, they're going to be organisations that process personal data on behalf of controllers. So that could be somebody like a cloud hosting provider or an outsourced payroll provider. And it's worth noting that a processor can be a third party, but it could also be a member of the same group as the controller. Data subject rights have been strengthened by the GDPR. So you might have already heard of data subject access rights, where an individual can request copies of all of the data that's being held about them by a controller. The GDPR also introduces additional rights, such as the rectification of incorrect data, the erasure of personal data that's no longer needed, a right to obtain electronic data in a commonly used machine-readable format, and an opportunity to object or restrict data that's being processed in certain circumstances, such as where there's been a dispute about the lawfulness of the underlying data processing. The GDPR also introduces direct obligations on processors for the first time in relation to data security and data transfers. Previously, only the controller had direct liability under the legislation and then needed to flow down its responsibilities and liability through contractual terms, whereas now, processors can face enforcement proceedings directly if they fail to comply with their obligations. Under the GDPR, there's now a duty to report certain data security breaches to a supervisory authority within 72 hours of becoming aware of a breach, unless you can show that that breach is unlikely to result in a risk to the freedoms and rights of the affected individuals. You might also need to notify the individuals themselves if there is a high likelihood of risk to those individuals, whereas under the previous regime, there was no obligation, no statutory obligation to notify security breaches. And then there's a reason why the GDPR has grabbed everyone's attention, which is that the fines for non-compliance have increased to the greater of 4% of annual global turnover, or 20 million euros. Now, previously, in the UK, the maximum fine under the old legislation was £500,000. So the fines under the GDPR have seen such a marked increase, which is why people are taking such note of the GDPR. So now I just want to run through a number of the practical points that we've seen in relation to share plans. The first thing that we see is that there's too much reliance on consent. And even then, the consent wording that we see is often buried amongst other terms in the share plan documents or award agreements, which wouldn't satisfy the standard of consent required by the GDPR in any event. There's a common myth that controllers need consent to process personal data lawfully, whereas in practice we recommend that if you can if you can avoid relying on consent, then you should do so, if at all possible. And particularly in the employment context, there's additional reasons why you would do that. First of all, there's always going to be an argument that the imbalance of power in the employment relationship means that any consent you get from employees won't be freely given as required by the GDPR, so those consents that you might be getting might not be valid in any event. And where you do have valid consent, they can also be withdrawn at any time, which can cause headaches further down the line if you think you've got a valid consent and then an employee decides to withdraw it. Particularly if you've got one employee out of the whole, you've got a share plan, one employee decides to object to the processing, you could end up in all kinds of bother. To resolve this, we recommend that you consider other lawful bases of processing that you could rely on under the GDPR. So where possible, in the case of share plans, it's likely that you would be able to rely on the fact that processing is either necessary in relation to the contract that the person's entered into, which would be the award agreement, or the processing is likely to be necessary for the organisation's legitimate interests. The next thing that we tend to see is that often transparency and consent mechanisms are contained in the share plan rules or option award agreements themselves, rather than a separate fair processing notice. There's a requirement under the GDPR to be transparent with data subjects about how you process their personal data. The problems with including the information in the share plan rules or award agreement are that they often aren't made prominent enough within those documents to satisfy the transparency requirement in the first place. And then also, as a practical point, as the share plan continues, you can't update the information once it's in an award agreement. So, for example, if you changed your provider or the group structure, you would then have to amend the underlying option award agreement in order to give effect to those changes. So to solve this, we recommend that you include within the option award agreement a simple statement that the individual's personal data will be processed in accordance with a fair processing notice, and then you provide the information about how you're going to process the personal data in a separate fair processing notice. So basically, you take all of that information, you include a reference to another document, and you have the fair processing notice as that other document that deals with everything that you need to provide to satisfy the transparency requirement. We'll come on to, a little bit later, we'll come on to what information you need to have in those documents, but you'll see that it's because of the amount of information you need to provide, it's definitely much better to have that as a separate document anyway, because it makes the award agreements much less cumbersome. So by doing that, it avoids the data protection information from being buried in amongst other terms, and it gives flexibility so that you can update the notice by notifying individuals rather than having to amend those underlying award agreements or share plan documents. Another problem that we tend to see is that there's a lack of data sharing agreements in place in respect of share plans. Now, often share plans will involve sharing personal data across group companies, and in some cases you may also have a third party that's helping to administer the plan. Now, if there's any sharing or onward processing of personal data, it should be governed by a suitable agreement. We can come on a little bit later on as to what we mean by a suitable agreement. Also, having advised on a number of global share plans, we also see that organisations often fail to have appropriate safeguards in place in respect of any international data transfers. This isn't a problem limited to share plans, but it is something that we often see in the share plan context. Where personal data is going to be transferred outside the European Economic Area, which is basically all of the countries that make up the EU, plus Iceland, Liechtenstein and Norway, the GDPR requires that specific safeguards are implemented to protect the data once transferred, so that the data is protected by the same standards that would be the case if it was in the EU. We recommend that appropriate safeguards are put in place for all transfers of personal data, whether in relation to share plans or not, that relate to kind of European employees outside the EEA. And this is something, again, internally, you might want to discuss if you've got a privacy team to see what transfer mechanisms you've got in place and whether they cover any share plans that you're wanting to implement. In some cases, you might have Privacy Shield certification in relation to the US, but in many cases, the clients that we deal with don't, which means that the likelihood is that you would need to, in respect of all of those transfers, enter into EU model clause agreements, which are essentially standard form agreements that impose on the recipient of the information outside of the EEA the same, it obliges them to apply the same levels of protection to the data as would apply if that data was remaining within the EEA. And then our final recommendation is that you should also consider the wider implications of the GDPR. Obviously, we've got limited time now, so I'll focus on some of the more common pitfalls that we see. But there are wider implications of the GDPR and what you might want to do with personal data in relation to share plans. So, as an example, privacy by design, privacy by default, and the data minimization principle could all mean that you would need to consider data protection when you're planning and implementing the share plan. And also, you should only be processing personal data that's limited to what's necessary in order to operate the share plan. So you shouldn't be processing any information that's nice to have. It should be limited to what's necessary in order to provide the share plan. And then the final note of caution on this slide is just not to forget about local law requirements for employees that might be based outside the EU. Now, obviously, for this session, we focused on the GDPR here, but you might also need to get advice on local law requirements for jurisdictions that aren't governed by the GDPR. So it's just a note to also think about that when you're looking at share plans. Now, I won't spend too long on the next couple of slides, but I just wanted to highlight some of the requirements for the fair processing notices that you need to provide to individuals. Also discuss a few points to think about with data sharing agreements and data processing agreements. This slide lists all of the information that needs to be contained within each fair processing notice that's provided to the data subject about how you're going to process their data. And as you'll see, there's loads of information that needs to be provided. And as I mentioned earlier, this is another reason why it's better to have it in a separate document rather than trying to include it in the option award agreement or in the share plan rules, because all of this information needs to be provided. And again, it just makes those documents longer. It makes them more cumbersome. It makes them less accessible. A couple of points to note in respect of information that you need to provide to the individuals is that you need to tell the individual what your legal basis is for processing their personal data. So again, we talked about avoiding consent if possible. If you are relying on the fact that the processing is necessary for the performance of the option award agreement, you can just say that in the fair processing notice. But if you were looking to rely on the legitimate interest lawful basis for processing, what you would need to do is you need to undertake an assessment as to whether your interests are outweighed by the individual's rights. So if that processing is going to have a big impact on the individuals, then you wouldn't have a legitimate interest in the first place. And then also within the fair processing requirements, you need to tell the individual what your specific legitimate interests are once you've established whether you've got one or not. And again, in this case, it's most likely to be that the legitimate interest is the performance of the share plan. And we'd expect in most cases that that would be a justifiable legitimate interest. but again, you still need to do that assessment before you just go ahead and process the personal data anyway. And then the other thing I just wanted to mention in relation to the fair processing notice requirement is that the fair processing notice needs to tell the data subjects what safeguards you have in place in respect of any of those international transfers that I mentioned. Now, obviously, you can't tell people what safeguards you've got unless you've actually got them in place in the first place. So that's why thinking about these issues during the planning stage of a share plan is so important. And then just as a final comment on the fair processing notices, one thing that we found really useful, particularly in respect of global share plans, is thinking about how you can make the fair processing notices territory neutral. And that makes the rollout across multiple countries so much easier. So there you're thinking about things like, avoiding reference to laws that relate to a specific country. In the UK, sometimes there might be data sharing with HMRC, but actually, instead of saying that in the fair processing notice, if we're drafting it in the UK, to make it easier to roll out, you'd refer to sharing the data with the relevant tax authorities. Similar things you might be able to do is, instead of you have to give details of the identity and contact information of the controller, well, what you might do there is you might include those as a schedule to the fair processing notice and then refer in the notice itself to the person's employer. So again, just the certain mechanisms that you can think about to try and make it easier to roll out the fair processing notices across all jurisdictions. Then, if you use a third party to process personal data on your behalf in connection with a share plan, and that, as I said earlier, could be a third-party administrator or a group company. For example, if they're hosting the share plan data on their servers, then the GDPR requires that specific predetermined provisions are included in a written agreement between the two parties. Now, these predetermined provisions include obligations on the processor to do things like comply with your instructions, keep the personal data secure, provide assistance to you in respect of your obligations under the GDPR, delete or return the personal data at the end of the contract, provide information and permit audits to check that they're actually meeting their data protection compliance requirements, and immediately inform you if the processor believes that your instructions infringe data protection laws. Now, while these are predetermined and they're obligatory to have in any agreement that you have where somebody's processing personal data on your behalf, so that relates to share plans or otherwise, people do, because they are so onerous, these provisions, kind of struggle to just accept them. So again, you probably need to be building in time to negotiate your contracts with processors to reflect the fact that there probably will be some discussion about the provisions that you're wanting to put in place. In respect of data sharing contracts between controllers, such as where you're sharing personal data with a parent company, and where that parent company can itself determine how it's going to use that data, then that would make it a controller, in which case the agreement that you would need to have in place would be a data sharing arrangement and not a data processor or data processing arrangement. In those cases, the agreement should document the roles and responsibilities of each of the parties, require each party to comply with all applicable data protection laws, and also you might want to call out that each party will implement adequate security measures, just for good measure, to make sure that you're meeting that requirement of your own. All in all, I know that's a really quick canter through some of the GDPR obligations, but there's quite a few elements relating to data protection to consider when you're looking at your global share plans. And hopefully, whilst that was a bit of a whistle-stop tour, thinking about some of these practical points up front might help you to implement successful and compliant data share plans in the future. And that's all I had to say. So I'll pass you now on to Brenna, who's going to discuss Clawback in the US.
Thank you, James. For the remainder of the webinar, we're going to talk about compensation clawbacks, which is essentially when an employer takes back amounts that have already been paid to an employee, generally because the employee has violated some sort of company policy or an agreement, or maybe the employee has violated some law. And as you're going to hear, the rules and the effectiveness of these types of clause vary pretty widely across jurisdictions. For example, in the U.S., while they may be fairly common and considered good corporate governance, in France, you might have you have much stricter protections on the employee side, and they're definitely not viewed as something you may want. And Vincent will talk a little bit more about that in a few minutes. And so we'll spend the rest of the webinar talking a little bit about that. So I'm going to talk a little bit about the U.S. As I mentioned, these are fairly common in the U.S., and we have two main laws that might require compensation clawbacks. The first of those is Sarbanes-Oxley, and what that does is that will allow the SEC to require a public company to claw back any CEO or CFO compensation if the CEO or CFO has had any misconduct that results in a material financial restatement. And then we also have the Dodd-Frank Act, which is a bit broader. That one is not in effect yet. We have some proposed regulations, but it is not actually in effect. And what that requires, once these regulations become effective, is that public companies adopt policies for both current and former executive officers. So it's a bit broader than Sarbanes-Oxley. And that will apply in the event of a material financial restatement, even if the officer is not at fault. So under Dodd-Frank, you might be clawing back amounts even if there is no misconduct. And so as I mentioned, here most public companies have already implemented a clawback policy just as a matter of corporate governance. Estimates that we have estimate that maybe 92% of the S&P 500 have some sort of clawback policy already. That being said, the terms vary pretty widely right now. Some of the key design issues that we might see, will you claw back compensation if the employee is at fault, or are you going to claw it back even if the employee has not actually had any misconduct and may not be at fault? Additionally, some things that companies may look at are, how far back will you go? Will you go back 2 years, 3 years, something more than that? And, another thing that we might see is, is the clawback automatic, or is it something that the company might choose to implement? So, at this point, we still see quite a bit of variation here in the U.S. And one of the big issues that we see here in the U.S., one of the things that gets kind of tricky are the tax issues associated with clawback provisions. If an employee gets paid in 1 year and the company decides to claw back that amount in the same year, it's typically fairly simple. We treat the amount clawed back as though it was never paid. But of course, in most cases, when we have these types of clawback provisions, what's going to happen is you're going to pay an employee in year 1 and then decide to recoup it in some subsequent year. And so there, we run into some questions of how exactly do you report this? How does the company take a deduction when this happens? And what we have seen is that if you pay an amount in year 1 and then you decide that you need to claw that money back, let's say you're going to withhold that amount from the second year's incentive award, you still have to report the full value of that second year's incentive award as W-2 income for the employee. It's still all subject to income tax. So you can't just net out the amount and not report that amount that's been clawed back. And then what happens is the employee then has to deduct the repayment to the company or any amounts that have been withheld from that second year's compensation. He has to report that on his own tax return. It's up to the employee to get that deduction. And then what the employer can do is it can recover the FICA taxes that might have been paid in year 1, as long as the statute of limitations hasn't passed. On the company side, if you're paying an amount in 1 year and the company's taking a deduction there and then recouping it in a subsequent year, when the company recoups that amount, generally the company needs to take that amount back into income in the year of recoupment. So, if you're withholding amounts from that year 2's compensation, then that's going to be considered income to the company for that second year. And then, one other issue that I will touch on here, I'm not going to get too deep into it today, is Code Section 409A. And here in the U.S., that's a complicated tax rule that governs deferred compensation. So I did want to note that when you are trying to withhold amounts from anything that might be considered deferred compensation, you could be running into 409A issues because you could, if you're not careful, you could essentially be changing the payment timing, which is prohibited under 409A, and that will result in some pretty big tax penalties. So I just wanted to highlight that that's one thing to be aware of. Any time that you're going to, be recouping money from some other amount that you're going to be paying to your employee. And so with that, I am going to turn it over to our colleague, Mathew Gorringe. Before I do, though, I just wanted to mention that if you're interested in receiving CLE credit for today's presentation, you need to write in the confirmation code the term clawback, so that's CLAWBACK, on your CLE sign-in form, and you can find that on your viewing console.
Thanks, Brenna. Just moving into the UK position, it's not dissimilar to the US. Clawback provisions allow the company to recover amounts that have already been paid under a stock incentive or share incentive plan to an executive. The corporate governance code in the UK really requires that companies give consideration to putting these clawback provisions in place, but most companies do, and there is certainly a sort of copycat culture that similar provisions used in one plan are used in other plans. Although plans do vary around the clawback provisions, it's very usual to find that they focus on particular events which could give rise to clawback, and the three main events are a material misstatement of results of the company, whether or not that's something that is the fault of a particular award holder, the gross misconduct of an award holder, or an error, in fact, in assessing the performance conditions relating to an award, whether or not that is the fault of the award holder. So they're the three key clawback events. You touched on the clawback period, and I noted you mentioned about Dodd-Frank's recommending a particular period of 3 years. In the UK, it's typical to have a clawback period of 2 or 3 years after an award has vested. That's the usual approach. And the clawback recovery can be orchestrated by the withholding from future bonus payments made to the executive from scaling back unvested awards, or requesting a cash payment directly from the award holder. I think everyone in the audience will guess which is the most favourite there as far as award holders are concerned, because it's far easier to scale back an unvested award, i.e. something the executive hasn't yet received, than to actually physically ask him to pay over money or withhold money from a forthcoming bonus. Basically, one of the things that we have to be careful of in the UK is what amount is clawed back, because it links to the enforceability of the clawback. In the UK, these provisions will be enforceable unless they amount to an unlawful penalty. And now, an unlawful penalty is something which requires a payment from an employee in connection with a breach of contract, but the amount is obscene, or it's too much. It doesn't really cover the damage or go to the damage suffered, and therefore it's really a deterrent rather than a recovery of loss. Now, in the circumstance of UK clawback, where there is a clawback where the performance targets have been misstated or the financial results have been misstated, and that's resulted in more shares vesting than would have been the case had there been no such error or misstatement, it's very easy to quantify the loss, and there's simply the difference between the two scenarios. Where it gets a little bit muddy in the UK is where you're seeking to recover or use the clawback provision against an award holder who is guilty of gross misconduct, because in those circumstances there is no easy measure of the damage suffered by the company, so the penalty argument door can remain open. So it is something to watch. And I'm just conscious of time, and we need to hear from France, Italy, and Spain on clawbacks. So I'm going to hand over now, if I may, to my colleague Louis in Spain.
Thank you, Matthew, and hi, everybody. So basically, the position in Spain is pretty or substantially different to the one that my colleagues have highlighted before. The real issue here is that we do not have a clear legal framework for these sort of clauses in employment contracts. So there's a lack of legal definition as such that leads to some degree of uncertainty as to whether these provisions can be enforceable under Spanish employment law. There's also a lack of clear case law precedents, and most important, the fact that it's a notably lack of case law from Spanish Supreme Court, which is the leading tribunal in terms of case law here. So all in all, a conservative approach for clients is recommended for as long as there's not clear framework, and therefore the enforcement of these sort of clauses, the inclusion of these sort of clauses can come with enforceability issues or be problematic. Given the lack of clear legal background in order to determine whether or not these clauses are valid, we need to take into account here basic principles of Spanish employment law. And basically, we need to take into account that our legal system for employment relationships takes a very paternalistic and pro-employee approach. And this is especially noticeable from employment tribunals here in courts. And you can pretty much say that the in dubio pro operario, which is the when in doubt, fail in favor of the employee principle, is going to be widely applied. So assessment on a case-by-case basis of the intended wording for the clawback provision is always of the essence. Another additional issue that may come with these clauses is that there's a general principle under Spanish employment law, which is the fact that the employee cannot be subject to financial penalties, and that as such, you can likely run the argument that if this is going to be a detrimental, it's going to have a clear financial detrimental effect on the employee, this is not probably going to be considered as a valid provision under Spanish employment law. An additional point is that in terms of what type of penalties or what sort of penalties you can impose on an employee, in Spain, leaving aside the fact that we said before that you cannot impose financial penalties, there's a closed list, there's a shopping list for the infringements that an employee can incur on, and the consequences that the employer can take, depending on the type of infringement. And this may go from suspension of employment up to termination, dismissal. So, but again, it's a closed shopping list, and therefore it is not possible for the employer to come up with different consequences or effects for the alleged breaches from the employee. Also, there's a general principle that the salary deductions carried out in payroll need the employee's valid consent, and that if not, the amount sought by the company will definitely need will require court action by the company filed against the employee, and this is subject to a general statute of limitations of 1 year. This is also something interesting, and this also applies to damages sought against employees, which, besides the possible penalties, damages against employees are extremely restricted to the most serious and willful cases where the damage and the relationship between the employee's action and the effect can clearly be evidenced by the company, and subject always to the judge's discretion or ability to moderate or reduce the damages sought. And just finally, just a reminder that in Spain, the concept of salary is very linked to its social purpose, to the intended social object of the salary, which is in fact the employee's right to take on this salary and use it in order to plan life plans and to enjoy the salary, and it will be, therefore there's a general principle that this will be considered unfair for the employee. And again, the main social security and tax implications that we can also think of are very similar to the ones that my colleague Brenna said before. So it will be problematic to, again, backdate or to go back to previous statements, both for Social Security and tax purposes, and to regulate or to regularize, the already provided forms for the tax and Social Security. So that's pretty much it from Spain.
Yes, here in Italy, we have, in general, a situation which is similar to the situation described by Luis for Spain, in the sense that we do not have a legal framework for clawback here in our system, and the law is, in general, silent in this respect. We do have, however, a general principle by means of which the employee is obliged to repay damages caused to the employer if those damages are demonstrated in court. So what could happen in practice is that the clawback might be allowed when the award holder is dismissed for a just cause, for a gross misconduct, and as a consequence of such misconduct, the employer was damaged. So if, as an outcome of a proceeding in court, a damage is demonstrated and is ascertained that such damage is attributable to the misconduct of the employee and award holder, then the employer is entitled to start a legal action in order to obtain the compensation for such damages, and in order to do so, the employer is entitled either to distrain the shares or to distrain the corresponding value in money. This rule, which is not a written rule but is a general principle, exists in our system, which is applied in case law references, might cause problems if the award holder, as always happens, challenges the dismissal, and the court determines that such dismissal is unfair. And this might also happen in appeal or even in Supreme Court, which means that the final outcome of the proceeding might occur after years from the dismissal. And if this occurs, the award holder is obviously entitled to claim back the corresponding value of the shares in money. Aside from these cases, as I said, there are no rules in place in our system, and basically there are very few possibilities for the employer to enforce a clawback provision, unless, however, if the stock plan rules contain clawback provisions that allow the clawback in certain circumstances. And if the employee has accepted such rules and never challenged those rules, then clawback might be effective also in cases different from the cases described above. But this is something which is entirely left to the negotiation of the parties, and it is entirely left to the rules which are set out in the plan, in the stock plan. And these are basically the rules existing in our system.
Thank you very much. That's really, really helpful, Marcello. And last, we'll just hear from Vincent in France on clawback.
Yeah, thank you. Okay, so French law does not really know the clawback provision. And there is no legal rules, there is no case law, and to be honest, it is not the market practice for employees' benefits. So to our client, we recommend the company to be very careful about such a clause. The risk regarding French law is that in case of litigation, the court rules that the clause is not enforceable to the employee and to the employee. Nevertheless, because there is no regulation, from our perspective, we can make a distinction regarding the beneficiaries of the plan or of the bonus. If the plan benefits to employees only, the position must be defensive. The employer can neither unilaterally deduct a portion of the salary of the employee, nor ask the employee to get the money back, even if the employee leaves the company or committed gross misconduct. There is a general prohibition of financial penalties. Nevertheless, the employer can provide subject and bonuses and shares to condition, and if an award has not yet been vested, a reduction due to poor performance can be decided by the company if this reduction is stated in the plan. If the plan benefits to managers with corporate office only, the company can choose a more offensive position. If the plan has been implemented in another jurisdiction, and if the plan is subject to another law, we assume that the French court will apply the foreign law even if the manager is French and works for a French company. So if the plan stated a clawback provision, this clawback provision will be enforceable to the manager. And we could think about directly implementing a clawback clause in French plan. In such a case, we consider that several conditions should be satisfied. First, the approval of the company and the manager about the clawback provision. Second, the amounts to be deducted. And third, the conditions of the deductions. But it's not the market practice in France now. Thank you.
Thank you, Vincent. That's really great. So, Brenna, I don't know if we've got any time for questions.
We do. We have a few minutes for questions. One question that I see that has come in, and this is probably more for our colleagues in the UK, has asked, what sort of impact Brexit might have on these topics that we've discussed today.
That's a very interesting question, especially in light of what's happening in the UK at the moment, and particularly the last couple of days. James, I think one of the important things about Brexit is obviously GDPR and its impact on GDPR. Would you care to give a view on that?
Yeah, sure. In terms of the GDPR requirements generally, so all of the things that I mentioned earlier, none of those will be affected by Brexit. So in the UK, on the same day that we implemented the GDPR, we also brought into force the Data Protection Act 1998, that's the old one, the Data Protection Act 2018, and that basically incorporated all of the GDPR requirements into English law. So all of those requirements will remain the same post-Brexit, and they are in force now in the UK and will remain as such. And one area that might be interesting, though, is, and again, I don't want to turn this into a GDPR talk because I could probably talk about GDPR all day, but one of the areas that might cause some concern is around data transfers. So data transfers from the UK to Europe will be fine because all of the European jurisdictions will be subjected to GDPR. But at the moment, we don't have an adequacy decision in respect of the UK for any transfers of data from the European entities or from European countries when they're transferring personal data to the UK. So one of the areas we'll need to look at, and again, it's not clear yet, and we'll have a look at whether there is going to be an adequacy decision about the rules and regulations we have in the UK as part of the Brexit deal. But again, it's uncertain. There isn't one at the moment. And if we don't have that adequacy decision, which means that we can transfer data in the same way that we do currently, then we will need to look at putting in place safeguards such as those model clauses that I mentioned earlier in respect of the transfers from the European jurisdictions into the UK. Even though all of the same rules and regulations apply, it's a slight nuance where we would fall outside of the EEA and we wouldn't have been given a separate adequacy decision, so we would need to then look at those transfer mechanisms.
That's quite an interesting position to be in. I think from the securities law perspective, it's not actually dissimilar. The prospectus regulation, obviously to the extent that it has been already adopted by the UK, will continue to have force, and so I would expect the securities regime won't actually change as a result of Brexit, certainly in the UK. Unless the UK post-Brexit decides to introduce new securities laws, which of course, depending on the outcome of Brexit, it may be free to do. So I would expect the securities position to actually remain pretty much the same post-Brexit as it currently stands. But it's a bit of a wait and see what happens, and I think that's probably the same on the position with data transfers from EU countries to Britain as well. It's just going to be a kind of wait and see what happens. Any other questions from anyone?
Mathew, I think with that, we're nearing the end of our hour.
Excellent.
And so I wanted to thank everyone for attending today. And with that, I think we will let you go.
Thank you very much, Brenna.
Thank you.
Many thanks.
Thank you.
Thank you.